My name's Aileen McCulloch, and I'm a professor at King's from time to time in the law school, and it's my great pleasure to welcome you to this debate this afternoon. Debate, of course, is the Human Rights Act, Bill of Rights for the 21st century, and we've got four extremely interesting and eminent speakers for your delectation, and I'll introduce them simply as their turn comes. So first of all, we'll start with Lord Phillips of Matravers, and his great claim to fame is, of course, that he's a professor now in the law school, but which is the most interesting and important thing about him. But in the build-up to that esteemed role, he was most recently, of course, president and first president of the UK Supreme Court, and studied, in fact, at King's in London, and had, of course, a marvellous and glittering career. But it's all been leading up to this, the moment when he joined the school in November 2012 as a professor. So I'm going to ask Lord Phillips to start. We have to pass the microphones around, and everyone will have around 10 minutes, though I'll be slightly generous.
Thank you. Well, this year we are celebrating the 800th anniversary of the sealing of Magna Carta with an almost religious fervour. This would certainly have astonished King John. He'd never himself had the slightest intention of paying any attention to its provisions. In 1213, he'd reached an accord with the Pope, a man as devious as he was himself. Pope Innocent III, misnamed, was an Italian count who'd succeeded in being elected to Pope only 2 days after he was ordained as a priest. During the uprising of the barons that led to Magna Carta, John had been secretly briefing against them in correspondence with the Pope, to the extent that in July 1215, unaware, of course, of the sealing of the Charter, the Pope excommunicated, I quote, all such disturbers of the King and Kingdom of England. No sooner had he sealed the Charter than John sent a message to the Pope requesting him to annul it. In August, the Pope obliged, sending letters condemning the Charter as exacted by extortion and declaring it to be null and void and of no validity whatsoever. Civil war broke out, and John's health broke down. The rebels invited Louis of France to come to take the throne of England, but before he could do so, John died at Newark. So as far as subjecting John to the rule of law is concerned, Magna Carta was something of a non-event. The chapters of Magna Carta were not numbered. It was Blackstone in the 18th century who gave them numbers, and using those numbers, we find that the provisions of Magna Carta that are considered so important today were not at the forefront of the Charter. The early chapters sought to place an embargo on the many ways in which King John had used the financial rights and privileges of the king to extort money from the barons. It's not until chapters 39 and 40 that we find this. No free man shall be arrested or imprisoned or diseased or outlawed or exiled or in any way victimized. Neither will we attack him or send anyone to attack him except by the lawful judgment of his peers or by the law of the land. To no one will we sell, to no one will we refuse or delay right or justice. These powerful provisions did not die with John. In 1225, his son and heir, Henry III, having come of age, put his own seal to a revised edition of his father's charter, in which chapters 39 and 40 became chapter 29. And this chapter, with amendments, was reissued by subsequent monarchs, and in the reign of Henry VI, Parliament passed a statute that incorporated the provisions of chapter 29, and they've remained on the statute book ever since. The importance of these provisions lies not in their meaning in the 13th century, which is by no means clear. It lies in the meaning attached to them by Sir Edward Coke in the 17th century. According to Coke, chapter 29 had guaranteed the rights to trial by jury, the protection of the writ of habeas corpus, and the supremacy of the common law, none of which were features of the legal landscape at the time of King John. More broadly, Magna Carta became seen as the instrument that subjected even the king to the rule of law. On the restoration of Charles II, the Speaker of the House thanked him for restoring to us our Magna Carta liberties. There followed the colonization of America, under which the charters of several of the colonies borrowed directly from Chapter 29. And after the Declaration of Independence, 9 former colonies inserted into their constitutional bills of rights provisions which bore a close resemblance to Chapter 29, as did, of course, the Bill of Rights that was added by amendment to the federal constitution itself. So the Fifth Amendment provides that no person shall be deprived of life, liberty, or property without due process of law, and the Sixth Amendment guarantees the right to trial by jury, all of which they felt had their origin in Magna Carta. And thus it is that in recent times, perhaps until this year, Magna Carta has been more revered in the United States than in this country. On the 8th of March 1951, this country became the first state to ratify the European Convention on Human Rights. We played a major role in drafting the convention. Our motives in participating in this venture were not a belief that this country would benefit from the discipline imposed under the convention. It was the belief that other members of the Council of Europe should be under the obligations that it imposed, so that never again would Europe see the human rights abuses that had in part provoked and accompanied the Second World War. In 1996, this country accepted the right of individual petition to the European Court of Human Rights. Again, I suspect, largely with the intention of setting a good example to others. At that time, only 2 cases had been decided by the court. Since then, compared to other countries, the United Kingdom has always done pretty well before the Strasbourg Court. The vast majority of applications made against the United Kingdom are ruled inadmissible or ultimately fail. But nonetheless, over the years, the Strasbourg Court has given a significant number of judgments against the United Kingdom. Our treatment of prisoners is one area where we've been found wanting on a number of occasions. The fact that we're losing quite a lot of cases at Strasbourg made many think that there was something wrong with the system. The United Kingdom had never given domestic effect to the Human Rights Convention, so individuals had no right to bring claims in the British courts for violation of the rights that the country had agreed that they should enjoy. Far too many applications were being made to Strasbourg in cases that could have been dealt with domestically. This meant that British judges were not given the opportunity to express their views on the ambit of the Convention rights and whether in the particular cases they had been infringed, so that when the case got to Strasbourg, the court did not have the benefit of those views. It was to remedy these perceived deficiencies that the Human Rights Act was passed in 1998 under a Labour government. Bringing human rights home was the object of the exercise. But since then, there has developed a groundswell of dissatisfaction with the working of the Convention on 2 grounds. First, there's been a reaction against some of the decisions of the Strasbourg Court. It has been seen to be enlarging illegitimately its overall jurisdiction and intervening in areas that should be left to the domestic courts and authorities in accordance with the principles of subsidiarity and the margin of appreciation. Secondly, our courts, and particularly the House of Lords and now the Supreme Court, have been thought to be too subservient to the Strasbourg Court. The Human Rights Act Section 2 requires the court to take account of the Strasbourg jurisprudence, but not slavishly to follow every decision as if it were a binding precedent. This dissatisfaction came to a head when Strasbourg delivered its decision in the case of Hurst, holding that it was contrary to the Convention to impose a blanket ban on all convicted prisoners from voting. The House of Commons passed a resolution that came close to unanimity, rejecting this decision. Nonetheless, a joint cross-party committee, of which I was one, advised that the government that it should introduce legislation granting the vote to prisoners serving a sentence of less than 1 year, which we hoped would satisfy Strasbourg. Well, the government has not complied with this advice, and that is something I greatly regret. The Conservatives propose to introduce a Bill of Rights that is intended, as I understand it, to give the Supreme Court rather than the Strasbourg court, the last word on the correct interpretation of the rights in the Human Rights Convention. I have yet to see a draft of this, but in principle I am not in favour. I agree with the view that was expressed by Lord Bingham, that under the scheme of the Convention, it is ultimately for the Strasbourg court to give authoritative rulings on its effect. I emphasise the word ultimately. Before according the Strasbourg court that last word, there is room for dialogue between the Supreme Court and the Strasbourg court. If the Supreme Court believes that a decision of the Strasbourg court has wrongly held the United Kingdom at fault, it can decline to follow the decision in question, explaining why it thinks that Strasbourg has got it wrong. And the Strasbourg court has recently responded to such dialogue by reconsidering its earlier decisions in the cases of Horncastle and of Hutchinson. At the end of the day, however, I believe that Strasbourg must have the last word. And this country is under an obligation under international law to comply with judgments that the court gives against it. Insofar as this proposed Bill of Rights requires the courts of this country to do their own thing without reference to the Strasbourg jurisprudence, it will be at odds with that obligation. The reason why we signed up to the Convention, namely to set an example to others, applies as strongly today as it ever did. If we do not comply with our international obligations under the Convention, that example will be a very bad one rather than a good one. Thank you.
Many thanks. There'll be... Actually, can I take one? Sorry. Thank you. There'll be opportunity for questions later, but next we'll hear from John Wadham, who shares with Lord Phillips the great delight of being a member of the law school at King's, the Dickson Poon School of Law, I should say. John was recently appointed Senior Visiting Research Fellow at King's. Prior to that, he's been General Counsel for the Equal Opportunities, or the Equality and Human Rights Commission, Executive Director of Inter-Rights, Deputy Chair of the Independent Police Complaints Commission, amongst other roles. So John will now address us on the subject.
Thank you very much. Well, after Lord Phillips has spoken, I'm not really sure whether there's anything much that I can add. I think it is worth looking at the proposals of the different political parties for the Human Rights Act and the ECHR in the context of the election that's coming up. And it's probably true to say that the Conservative Party has more detailed proposals than any of the other parties. That's partly, I think, because they have the other parties are happy or vaguely happy, or if they are unhappy, such as the UKIP or the DUP, they are completely unhappy and they want to get rid of it all, as far as I can tell. So this is not a... My analysis of the Conservative Party proposals is not a political one in the sense of selecting one rather than another, but because there are... That's obviously... The details are there, and obviously, as everybody says, you know, there's a choice between Cameron and Miliband, and that's so whether that's true or not, we can debate. So what the proposals say, and we haven't seen the draft bill yet, but at the heart of the reform will be a British Bill of Rights and Responsibilities which will restore common sense on the application of human rights in the UK. I'm not quite sure what common sense means. Presumably it means something different than the Strasbourg court has said. A draft will be published before Christmas. Well, that didn't happen. And among other things, it will stop terrorists and other serious foreign criminals who pose a threat to our society from using human rights to prevent deportation. Well, first of all, I think that's wrong in principle, because it implies that it would be possible to send people to countries where they're going to be subject to some violation of their rights, and presumably the one thing that's there, I mean, there are two key issues in relation to that, perhaps three. One is whether there's like to be a gross violation of someone's Article 6 rights, the right to a fair trial. Secondly, that there might be a breach of their right to family life, Article 8. but also, of course, the issue about whether they're going to be subject to torture, inhuman treatment or punishment. Now, in relation to all of those issues, those are not issues merely from the Human Rights Act or merely from the European Convention of Human Rights. They would be contrary to the other conventions, whether that's the International Covenant on Civil and Political Rights or the Convention Against Torture, and to some extent those are problematic issues. Now, my experience of dealing with governments of both hues for a long time is that they rarely take account of international treaty obligations unless there's some stick attached. The stick being is recently, obviously, the European Court of Human Rights up until 2000, and then the domestic courts being able to interpret that. So my guess is this is a proposal to say, well, actually, we don't really care much about UN treaties. I'm not really sure what that is about in terms of international human rights. But anyway, the other issue, of course, is that it creates some problems in itself in relation to those individuals, because what human rights is about, and I'm sure I don't need to tell this audience, what human rights is about is protecting people who are vulnerable or who are bad people that no one else is going to support. So you're never going to get leaders in the Daily Mail, the Times, the Telegraph, the Guardian supporting these people, saying, oh, they're lovely, they should stay here. That's why democracy, or a kind of simplistic version of democracy where Parliament rules and Parliament rules alone isn't adequate to protect our democratic values, which means that we don't, which I think includes the right to a fair trial and obviously family life and the prohibition on torture and human and degrading treatment and punishment, etc. But nevertheless, some people have a simplistic approach to democracy, say, okay, well, when Parliament decides, as it did, that we will lock people up indefinitely because we can't deport them, then Parliament will pass that legislation. They did. The Commons and the Lords passed that legislation, and people were locked up for long periods, and they weren't able to be tried, allegedly, though it's obviously on the basis of secret information and secret intelligence, allegedly because we couldn't prosecute them under the criminal law and use the due process that we would usually apply to such people. So that's the kind of thing that Parliament does, and I'm sure there are other examples, whether it's about DNA databases or lists of people on various police databases, etc., that is problematic. That's why I think we need it. Now, what has been said about the Conservative Party's proposals is this: these proposals threaten to create domestic constitutional difficulties and to undermine our international reputation and influence for entirely illusory benefits. It ought to be obvious to the paper's authors that such an outcome is impossible without destroying the Convention's effectiveness. Why should a state subject to an adverse judgment comply with it if the UK can ignore its own rulings? The proposal undermines entirely the principles that underpin international law. It represents a failure of ambition by the Conservative Party on the global promotion of human rights and is contrary to the line that we have previously maintained in government. I didn't say that. The previous Attorney General, Dominic Grieve, who unfortunately can't come today to talk about this, said that. It seems to me that therefore there are, if that's the case, there are real problematic issues with this. Now, the Human Rights Act came into force 15 years ago. It's been given some kind of quasi-constitutional status to the extent that that's possible under our constitutional arrangements. But it's under threat, and it's under threat by a government that doesn't like it. Now, whether the dominant part of the current government, those people who need reminding, the current Prime Minister in 2010 at the Tory party conference before the election said, I'm going to abolish the Human Rights Act. He wasn't able to do so, but the only reason he wasn't able to do so was because of the Lib Dem coalition, who then set up a Bill of Rights Commission. So I think there is something problematic of that, and there's been endless lawyers and NGOs and academics writing about critiquing the proposals, and it may well be that the proposals turn out to be completely different when the bill is published or when after the election if the Conservative Party is elected on any basis when they produce those proposals. But of course, human rights are controversial, and of course decisions, whether they're made by the domestic court or the Strasbourg court, are going to be controversial because they concern people who actually need protection but are not going to get that protection from anyone else. I think that it's true, as Lord Phillips said, that there's been a nice dance between the domestic courts, particularly the Supreme Court and the House of Lords, and the Strasbourg Court, where the Strasbourg Court has listened to the debate in our domestic courts and has changed its positions. My view is actually, though, the Strasbourg Court has been a little too cautious in its implementation of those proposals and listens too much. But my guess is judges, like other people, are political and are listening to the debate in this country and are bending the Strasbourg rules, or not being as judicially activist as perhaps I would like them to be, and have toned down what they've said, and that's been a regular experience. But nevertheless, the fact that there are checks and balances, both in the domestic proceedings and in the Strasbourg Court, is incredibly important. And I have to say, with the respect, with the utmost respect to judicial colleagues, my experience of international courts is they take a more clearer and conventional rule of law approach to the law than judges in domestic courts. And that's not just a question that I've learned from the UK. I work a lot for the Council of Europe, and it's the case in Ukraine, Moldova, Albania, Russia, etc. The courts in those countries tend to bend towards the executive. That's why we need an international court. Sometimes our courts do so, less often than those other courts. So I think the Bill of Rights that we have is the Human Rights Act. The Bill of Rights that we need is the Human Rights Act. I'm sure we could all look at other treaties that should be incorporated, whether that's the Convention on the Rights of People with Disabilities or the Children's Rights Convention should be incorporated as well. But actually, at the present time, we've got the best possible Bill of Rights that we can devise, I think, and it should stay with us. And just one point before I finish, though I have got a much longer lecture now. I'm an academic. There's lots of footnotes. I didn't bother with footnotes before. The whole thing about prisoners voting, personally speaking, I don't really care too much one way or the other. I think it is, I know there's a lot of debate about what was in the minds of those people that drafted it and the provision that deals with voting and elections, but nevertheless it's quite difficult to see why prisoners shouldn't be entitled to vote. Or at least take a classic example. Somebody is locked away following conviction for a short period, a week, 2 weeks, 3 weeks. They're politically engaged. Voting may be an important part to them, but they're only detained for a short period. And it happens to be when there's a general election, and it happens to be when there's a big debate about whether human rights should be abolished or not, or amended. Why shouldn't they? I don't understand why they shouldn't be given a vote. I understand why Hurst, who committed some very serious offences, shouldn't be given the vote, but nobody has ever suggested that that's the case. So I think that it's important that people who happen to be detained for short periods when there's an election should be entitled to vote. I mean, I don't understand why people are anti that. I mean, I don't think it's the most important violation of people's human rights in this country, but it's in the convention. And the key issue for me is the rule of law. The House of Commons voted to say we're not going to implement this judgment, even though we're signatories to this, even though the lawyers for the government argue against it, and they try to argue against it in other cases, and they failed. And now they say, okay, well, actually, we signed up to the rules, we understand what the rules were, but now we don't like the result, so actually we're going to shout at the referee a lot, and actually eventually we're going to take our ball away with us. I think that's unacceptable, and I can tell you from my experiences in some Eastern European countries, it goes down well with some people, governments, and it doesn't go down with other people who are struggling. In Ukraine, where I've been relatively recently, to create some new rule of law, to have processes which actually respect human rights, and what they say, well, what's your government going to do about this? Thank you.
you very much, John. Next, lest we're all in too much danger of disagreeing, I'm delighted to welcome Martin Howe QC, and among his many achievements, Martin has been on the Coalition Government's Commission on the Bill of Rights. That is the commission that was mentioned by John in his speech, and that commission, of course, reported at the end of 2012 with the recommendation for a UK Bill of Rights. Prior to that, Martin was a member of the Conservative Party's commission to create a Bill of Rights and Responsibilities. So I think we might stir it up a bit at this point. Thank you.
Well, indeed, and thank you very much. I may inject a slightly discordant note from two previous speakers, but let me just start off with a health warning. As you mentioned, I was a member of the Coalition Government's Commission on a Bill of Rights. That was a commission nominated by the Coalition Government, and therefore it had a wide range of views on it. And this was reflected in a wide range of outcomes in the report, with a majority report for a UK Bill of Rights, although, shall I put it this way, some divergence as to what should be in or not be in the bill. A minority report against the adoption of a UK Bill of Rights, and in fact a number of other interesting ideas which there isn't enough time to discuss this afternoon on other aspects of the whole process. Now, the Conservative Party announced last October its proposals for the repeal of the Human Rights Act, this was done not as a government proposal, because the Liberal Democrat Conservative coalition government, the coalition partners, shall I say this, don't see quite eye to eye on this issue, but a Conservative proposal for implementation after the general election if the Conservative Party is in a position to have a sufficient number of seats in the House of Commons to put it into effect. Now, I have been involved in advising on this, and I would like to explain my understanding of a number of aspects of it, although I must make it clear I am not an official spokesman for the party. Well, I personally strongly support these proposals, I should say. Now, the wellspring of the proposals, I think, comes from two considerations. One is that the effect of the Human Rights Act 1998 has been to, at least on one view, to incorporate a whole mass of jurisprudence, jurisprudence which in large measure is not domestic in origin. Now that itself may not be a bad thing in all respects, but we are, as a country, probably the country with the single longest continuous development of the protection of liberties under our law of any country in the world. And Lord Phillips' masterly introduction on the subject of Magna Carta, which in fact was really only the first stepping stone of many successive stepping stones in the protection of our liberties through the struggles before and during the English Civil War, through the Glorious Revolution, the adoption of the Bill of Rights of 1689 in England and the parallel claim of right in Scotland, and then successive developments both by statute and by common law. The Somerset case, where slavery was ruled to be entirely repugnant to the common law of England. Now, we've had this process of organic development, and then we've had, superimposed on it as a result of the 1998 Act, the introduction into our courts of the Convention and the Convention rights, in a way which has resulted, in many cases, in certainly in the early years of its introduction, to the older roots of many of the rights that are developed in the Convention having been overlooked. Now, in fact, quite recently, in Osborne Parole Board, there was a very significant Supreme Court case in which Lord Reed made an observation that the starting point for the enforcement interpretation and application of convention rights in this country should actually be their origin in the law of this country, and one should then look to develop from that in the light of the convention. Now that's a very welcome shift of emphasis, but it's something that in a way one wants to make more fundamental. Now the second part of the analysis, and this is going to be very controversial indeed, I'm sure, is regarding the jurisprudence of the Strasbourg Court and differentiating between the convention as originally written and as originally intended, and the jurisprudence of the Strasbourg Court in the 60 years since then, with the vast development of doctrines, elaborations, etc., etc. Now, the criticism that certainly I would come from the Strasbourg Court is not that, it gives judgments from time to time against the United Kingdom. Any system of international courts is bound to have occasions when an international court will disagree with you and give judgments against you. It's not as such that it, in certain respects, it's updated the interpretation of the convention with the passage of time. This is a case of sort of mixing up perhaps good arguments with bad arguments. Of course it's right that the protection of Article 8 for private correspondence, for privacy of correspondence, should apply to emails, even though emails didn't exist in 1950. No one in their right mind would argue the opposite. But under the guise of this sort of legitimate updating of the convention with time, a far more radical process of adding and engrafting doctrines onto the convention has taken place. And this creates problems, both democratic and constitutional, and to do with the rights of states and the obligations they assume. The Court of Human Rights at Strasbourg is not a democratically representative body. If we wanted to have a pan-European convention framing rights in a democratic fashion, we'd never have a system, one judge from one country and selection, one of three by the Parliamentary Assembly to create, to select them. It creates, therefore there's a constitutional deficit in that the states who are parties to the convention have never explicitly conferred this sort of law-making power on the judges of the Strasbourg Court, and there's a problem with the obligations of states that, having agreed, and this is particularly perhaps the case of our country, having agreed to the convention on the basis of what it meant and was understood to mean when we signed it and ratified it, we find ourselves being said we are bound by a different convention, the convention as quotes interpreted. I don't accept the accuracy of the word interpretation, but this is what the process is said to be. Now, therefore, I would suggest the problem that arises is one of looking very carefully at the relationship between the Strasbourg jurisprudence and the enforcement and application of convention rights in this country. And the Human Rights Act 1998 explicitly links interpretation to Strasbourg decisions, as is well known. In Section 2, Parliament has told the courts that they must take into account decisions of the Strasbourg Court. Now, in fact, the House of Lords in particular went perhaps rather further than the statutory language, certainly further than the statutory language mandates, whether arguably permits is another matter, in the Alconbury and other cases, where it held that where there's a consistent stream of Strasbourg jurisprudence, in effect the courts of this country are bound to follow it. Now, this has been criticised by no less a luminary than Lord Irvine of Lairg, important proponent of the Human Rights Act, as going too far. It's perhaps a sterile argument, though, to get into whether or not this is a correct exercise in statutory construction, because in a political context, coming up to an election, if the upshot is wrong, the answer is new legislation to correct the problem, rather than debating the impact and effect of the old legislation. Now that then brings us on to another aspect of the Human Rights Act, which is the question of the preservation of parliamentary sovereignty. because proponents of the Act said, and mechanistically correctly, that because of the declaration of incompatibility procedure, Parliament had the right to maintain legislation even though it was held incompatible by the courts with the Convention rights. Now that is so under the Act, but of course the problem then that gives rise to is if your courts say something's incompatible, it's not that likely, it's in the face of, say, a Supreme Court decision that your legislation is incompatible, that the United Kingdom could then successfully defend a petition at Strasbourg saying is compatible after all. Now, that's theoretically possible. It's not in practice very easy to see that happening. And that then creates a problem regarding the rule of law that some people anyway characterise as a problem regarding the rule of law, because it's a perfectly valid point to say if we have signed up to an international system under which a court has jurisdiction, one should certainly, at minimum, not likely then depart from decisions of the court, even if one disagrees with their reasoning or indeed the legitimacy of the processes by which they got there. And one could adopt a very narrow and formalistic posture, which is to point out that under the Convention, the obligation to respect the judgments of the Strasbourg Court is actually very narrow. It is simply to comply with the judgment in cases to which the state concerned is a party. Therefore, technically, all you need to do to comply with your international law obligations is to comply with the judgment to give compensation to the particular individual concerned, if that's what the court has ruled. That, however, is really rather a narrow interpretation of the rule of law, and would undoubtedly, and trying to continue, the prisoner voting business is more a question of inertia in the way it's developed than conscious continuation of policy. And then that leaves to a very unsatisfactory situation from the point of view of the rule of law of numerous repetitive claims by many individuals going to the Strasbourg Court. Therefore, the analysis of the Conservative Party is that human rights reform requires reform at two levels. One is reform at domestic level, the other, importantly, is reform at international level in order to resolve the issue of the rule of law. And that reform would be the preferred solution, if that can be negotiated, is a recognition of the United Kingdom's right to treat judgments of the Strasbourg Court as advisory only. If that cannot be negotiated, and I'm not going to go into, I'm not a diplomat, I'm not going to go into the diplomatics of this, and if that cannot be negotiated, the United Kingdom would exercise its legal right under the Convention to give notice of withdrawal, which indeed can be done on 6 months' notice. So the domestic provisions that would then replace the Human Rights Act, if I can give a very bird's-eye view of what they would say, first of all, they would incorporate the text of the Convention into domestic law. And indeed, there would be some additional matters that would be incorporated into domestic law. In fact, your observation about torture and so forth, the intention is to incorporate Article 3 of the UN Convention Against Torture, which is an explicit international obligation not to return people to states where they may be subject to a risk of torture, into domestic law. That would be done as part of an overall rebalancing exercise. But the ultimate position would be that we would, the second important point is that the Convention rights would be reintegrated more fully, picking up and perhaps reinforcing the Osborne principle into domestic law, so that they would be treated, we hope, more as an organic development of existing rights than as a new import based on entirely new jurisprudence. And the Strasbourg Court would be placed at a similar level, its judgments would be entitled to respect, it would be placed at a similar level, though, to, for example, judgments of the higher courts of other common law, Commonwealth or other common law countries on interpretation of similar rights, to which our courts would be invited to pay the respect that they normally would. And the intention is not to, curtail the role of the courts in respecting and enforcing rights, but to restore a situation where, like with all other legislation, Parliament is ultimately supreme and ultimately can take the decision. There would also be a number of specific measures taken to provide guidance to the courts in areas where Strasbourg jurisprudence has been extremely problematical, apart from the obvious question of prisoner voting, where the Strasbourg court has chosen to erect on a short clause providing for the holding of free elections an elaborate structure of individual rights for voting qualified by criteria the court has dreamt up. The other areas for important reform would be the issue of the area of law deportation of terrorist suspects particularly, and the international extraterritorial effects of the convention as it has been interpreted by the Strasbourg court on, for example, the operations of British armed forces outside the United Kingdom. So thank you very much.
Thank you very much. Finally, I should say last but not least, we turn to Dr. Colm, who has the great misfortune of being a reader at UCL rather than King's, but he consoles himself with his position as General Rapporteur of the European Committee on Social Rights, and he's been on the committee since time began, having been Vice President for years after being a member for some time. So he also has served as a specialist legal advisor to the Joint Committee of the Joint Committee on Human Rights of the UK Parliament, and having abused him for his position at UCL, I'll now give him a plug for his book, which is he's published a book in most recent publication, 2012, Human Rights and the UK Constitution. So, Colm.
Thank you very much, Aileen. I'm going to begin with an anecdote. Apologies. I was at a conference in Renmin University in Beijing in autumn 2012, and it was an extremely interesting conference because it was organized between UCL, Renmin, which is the second highest ranked university and indeed law school in China, and Hong Kong University. It was funded by the British Council. The subject was rule of law, and it was basically part of the endless initiatives that Western countries do to try and sell the idea of the rule of law to a skeptical Chinese audience. And it was an extremely high-level conference. And there was a leading Court of Appeal judge who gave an excellent speech about the virtues of rule of law. There was contributors from Hong Kong. There was contributors from Renmin talking about the values of rule of law. And the discussion opened out to the floor. And the first question that came in, because people aren't fools in China, quite the contrary. The very first question was a three-pronged question. Why is the UK not implementing the Hearst judgment of the European Court of Human Rights? Why are senior UK ministers, including the Minister in charge of Justice, advocating withdrawal from the European Convention of Human Rights? Is the UK's formal stance that rule of law and human rights commitments are politically negotiable to suit its domestic interests? How does this stance vary from the Chinese government? First question, right in. I'm going to park that anecdote there, and I'm going to come back to it at the end. But I think it's an important point to sort of, just for now, I will simply say that the discussion we're having here has ramifications way beyond the boundaries of this room, or indeed the boundaries of this United Kingdom. I'm going to come back to that at the very, very end. Almost every liberal democracy has now introduced some form of system of judicial protection of rights to sort of act as some sort of brake on the passing impulses of parliamentary majorities, governments who get excited about something and then do something they end up regretting and apologizing for and awarding massive compensation 10, 15 years down the line. Most European states have an interesting two-tier system. They have their own domestic rights protection mechanism, like the German Basic Law, for example, And they have also, in fact all of them, have also incorporated the European Convention of Human Rights into their domestic legal systems, allowing it to be applied by national courts. So at two levels. Okay? In some countries, the ECHR operates as a safety net in exceptional cases, that the domestic law, like in Germany, domestic human rights guarantees do most of the heavy lifting. In other countries, it's the other way around, like in France until very recently, where actually the ECHR did a lot of the heavy lifting and domestic law was sort of underdeveloped. But there's this two-tier system in place. Now, the UK has a two-tier system of its own, but it's a slightly odd one. It's the Human Rights Act, which incorporates, as we all know, convention rights into UK law. What the UK does is that it relies quite heavily on the convention rights, as Martin has said. It sort of borrows the convention rights system and as a reference point, but not binding, the Strasbourg jurisprudence for its courts to act to protect rights domestically. This was done in 1998 for reasons we all know, a desire to enhance rights protection, a feeling that UK law was falling out of sync with Strasbourg standards and international human rights standards in general, but also as part of the Northern Ireland Peace Agreement, as part of devolution and so on. And there was vague discussion about whether the UK should have a whole-scale Bill of Rights, but in general the political mood was, there's no appetite for a big discussion. We couldn't agree on having a UK Bill of Rights. Let's just incorporate the Strasbourg jurisprudence. And the Conservative Party, among others, signed up in that in general principle. Since then, as we all know, controversy has surrounded the Human Rights Act and the status of the ECHR. There's been two principal points of attack. One I want to deal with very quickly. It's the argument made by the majority of the Bill of Rights Commission, of which Martin was a member, that the HRA has failed to put down deep roots in British culture, that it's not popular, it fails to resonate, it lacks the sort of symbolic resonance of centuries of tradition, etc., 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 and that there's a lot to be said for the UK developing its own native rights tradition, drawing upon perhaps the existing tradition of common law rights. Okay? That, I think, is an interesting argument, and I personally don't have a particular problem if the UK were to go away and draft a sort of Bill of Rights, along the rights set out in the German Basic Law, for example, or something similar that could do quite a lot of the heavy lifting and protecting rights in the UK. Okay? However, first of all, two very brief points about this. First of all, when people talk about this embedded tradition of rights protection in the UK, there's an extraordinary vagueness. For example, the common law rights that Martin was referring to, as recently discussed by the Supreme Court in Osborne, most of that jurisprudence, as most people know in this room, dates back maybe 20, 25 years to the early 1990s. And a lot of it is controversial. Lord Sumpton, currently a member of the Supreme Court, attacked many of those key cases and questioned the legitimacy of much of this jurisprudence in his Mann lecture in 2011. So when we refer to the sort of common law rights tradition which we can all draw upon, bear in mind there has always been a big question mark about it. And bear in mind we're a complex island, about more than one island, factoring in Northern Ireland. We're a complex entity, the UK. As I like to point out, Magna Carta has never formed part of Scottish law, for example. Many people south of the border don't know that, but I just use that as an example. Okay? And there's very little clarity as to what exactly would be in this new Bill of Rights. But I want to leave that issue aside. The second point of attack has been the argument that, put eloquently by Martin, that the main problem with the HRA has been how it's imported this sort of alien Strasbourg influence, how it sort of infected UK law with this sort of alien, dubious virus of jurisprudence coming in from Strasbourg, and how the link it establishes with the Strasbourg jurisprudence is highly problematic. First of all, very briefly, of course, the Human Rights Act doesn't bind the courts, the UK courts, to follow Strasbourg jurisprudence, as we're all aware. There has been a dispute, as Lord Phillips mentioned, about the extent to which the UK court should follow Strasbourg, the circumstances when it should depart, but it's certainly a decision to be made by the UK court. contrary to what the Prime Minister has said periodically, the UK Supreme Court is supreme in the UK, subject to parliamentary sovereignty. That's simply an established legal fact. Okay? But I want to focus in the time that's left to me about what the debate has really turned into, which is a debate about the status of Strasbourg jurisprudence and the role of the ECHR. There's been two main points of attack on this Strasbourg influence, and Martin dealt with both of these points of attack in his talk. The first line of attack is to question the jurisprudence of the Strasbourg court, that it's malfunctioning as a court. The second line of attack has been to sort of say that the nature of the court is incompatible with fundamental constitutional principles in the UK. In my view, neither of those points of criticism stands up to any sort of serious scrutiny. First of all, very briefly, the argument that the Strasbourg jurisprudence is in some way warped or odd. Martin mentioned, the way that the court has departed from what the countries originally signed up to. Now, this is a fascinating myth. I'm fascinated by this myth because it's achieved extraordinary traction, and it's complete hogwash, with due respect to Martin. There's a great article by Danny Nichol, Westminster law academic, who's no fan, by the way, of judicial protection of human rights and public law, around 10 years ago, where it goes back to the travaux préparatoires of the convention. People didn't agree on this notion that they'd be a narrow anti-Nazi set of rights. In fact, the French delegate, and this is France, an important country, one of the Allied powers, the French delegate actually said, we very much hope the court will expand and develop our understanding of human rights over time. So you go back to 1950, and this agreement that the convention was a narrow limited instrument just wasn't there. Certainly the UK delegates were putting forward that view of the convention. Other delegates, like the French delegate, were taking a radically different view. That's what happens, of course, with international conventions and treaties all the time. But just to complicate things as well, the living instrument interpretation of the court has been established since Golder and other cases in the early 1970s. In Dudgeon versus the UK, as none of you will need reminding, the ban on homosexual activity in Northern Ireland was struck down, okay, by a reading of Article 8 to extend privacy rights to gay people, okay, which would have been, many people in the room in 1950 wouldn't have envisaged that. But this was part, perhaps, of the horizon of possible interpretation. And certainly, by 1980, that was a decision of the Court of Human Rights. What has happened subsequently? We had, since Golder and Dudgeon, and by the way, I was just in primary school, just starting primary school when all of this was happening, we had the UK government repeatedly signing up again and again and again to the jurisdiction of the court, and finally in 1998 accepting permanent jurisdiction. We had all the Eastern European countries encouraged to come into the system, with the UK making that an active condition of entry to the Council of Europe. So in other words, this living jurisprudence of Strasbourg, the approach which has been embedded for 50 years plus, has always been part and parcel. It's something that the UK has actually actively endorsed. Incidentally, it also has a very, very close resemblance to some of the case law of the Privy Council, interpreting Caribbean constitutions, and the Canadian Supreme Court, which incidentally in Sauvé versus Attorney General around 10, 12 years ago, held that Canada's absolute ban on prisoners voting in violation of the Canadian Charter of Fundamental Rights. So there's nothing weird about the approach adopted by the court. Well, we can discuss the finer points of Sauvé, right? My reading is very different from what Martin has just whispered in my ear. And the whole point is there's nothing, the logic of the courts is identical. But also more importantly, and I want to wrap up on this point, this issue of there's a problem with this from a constitutional principle. The UK has signed up to lots of international treaty commitments, interpreted and applied by courts, which the UK is expected to respect. Only this week, or was it late last week, the UK lost a case before the International Tribunal for the Laws of the Sea in relation to Diego Garcia. Now, that's a determination by a court. Following Martin's logic, the notion that if a court does something that Parliament doesn't like, then this is intolerable burden on democratic rule in Britain. I would expect to see the next Tory government withdraw, not alone from the Court of Justice of the EU, leave that issue aside, not alone from Strasbourg, but also the International Court of Justice, the International Tribunal of the Laws of the Sea. I would see them reconsider any WTO arbitration panels, any trade panel, any form of extraterritorial adjudicative mechanism that would in some way be seen as constraining parliamentary power. And I think this sort of reductio ab absurdum, frankly, shows the problem. UK Parliament maintains sovereignty. It can decide to disregard a judgment. Prisoners aren't getting the right to vote in the UK. It may have to accept serious embarrassment. It may be under substantial pressure. It may have to eventually buckle under. But the choice remains with it. And what I hear from Martin and from the Conservative Party when they attack the fact that their choice is somewhat circumscribed by Strasbourg jurisprudence is a resentment that they're being put in an embarrassing position by judgments of the court. Nothing more fundamental than that. Finally, let me conclude. A key problem with all of these proposals, and I'm slightly mainlining something that Don McGreeve said in UCL in December, but I'm not quoting him, I want to emphasize this, is that they're careless. There's a carelessness about some of these proposals which is a little bit perturbing, being voiced at times to politicians of the Conservative Party. There's a carelessness about the potential internal ramifications. Taking ECHR jurisprudence out of domestic law may, for example, breach the Good Friday Agreement. It may require alteration to the devolution agreement. There are serious legal issues there. It also risks destabilizing existing UK law. Secondly, it's careless in terms of its external implications within Europe, undermining of the world's most successful rule of law human rights mechanism may have serious consequences. We're not just talking about Russia and Ukraine. We're talking about Hungary, we're talking about Poland, we're talking about almost every European country where Strasbourg operates as a check on executive overreach. And finally, going back to Beijing, it's careless in terms of the messages it projects about rule of law, about convenience, about the attitude that countries should adopt towards international human rights mechanisms, international court decisions. There's a dreadful carelessness about the current proposals that I think mean that they should be subject to a very, very, very serious second look. Thank you.
Thank you, Colm. And I'm sure Martin wants to come back on that, but before he gets the opportunity to do so, I'm going to invite interventions from the floor, whether they're in the form of questions or short contributions, with the emphasis on short. And I'll see how we go with three at a time. And they can be directed to particular speakers or not, as you please. So do I see any hands? Got one there. Oh gosh, there can't only be one person in the room. One there, one there. So we'll take those three in order first. Maliha, if you want. And will you introduce yourselves, if possible? Tell us who you are before you speak. You don't need a, I don't, if you...
Yeah, sure. Maliha Malik, King's College, London, of course. But it was an observation to Colm and then a question for Martin. The observation to Colm really is what you were saying about the historical travel preparatoire for the European Convention. Because of course the contemporary historical position on why the convention was introduced overturns all these assumptions that it was a response to Nazism, World War II, etc. Because Sam Moyn's book, History of Human Rights, sort of shows, I think, really persuasively the way in which the convention emerges as part of a move by Western powers to actually try and rebalance the rise of communism in the Eastern Bloc. So I think it shows that the background is much more complicated than we often assume when we try and make these sort of common assumptions about what the convention was about. But I suppose the question to Martin was to just help me with a political kind of analysis of where the energy is coming from, the anti-Human Rights Act, anti-Europe, not just the Council of Europe, but European Union energy is coming from within his party. Because when we look at the polling data across the United Kingdom as a whole, sort of, Scotland, Wales, sort of lesser Northern Ireland, but the main sort of anti-European bloc seems to be England, right? So if we look at polling data, the Scots aren't that worried about pulling out of the Council of Europe or the European Union. The Welsh aren't. And so it seems to be an English phenomenon. It seems to be an English phenomenon that seems to be concentrated certain parts of the Conservative Party. So in a way I wanted to ask you a question as someone sort of, who knows more about the politics than us law academics, about where is this incredible sort of visceral energy coming from within the Conservative Party in terms of both a referendum in Europe, but also more importantly for our topic today, in terms of resistance to the Council of Europe and the European Convention.
Thanks very much. And yes.
Maybe a microphone or not?
No, if stand up perhaps and speak out.
Just stand up. Okay, Robert Craig. I'm teaching public law at LSE, and I used to teach at King. And I studied at King. I've never been to UCL. So I don't know if I'm going to kind of answer Malia or kind of address Malia's similar point, but perhaps from the other angle. My issue is the notion that the Constitution of the United Kingdom, or of England particularly, which is a positivist constitution, which is based on flexibility, and which is based on the abhorrence of rigid kind of constitutional laws in sort of Diceian sense, how that is reconcilable with the human rights discourse that there's a creeping power to it, which is inevitable and like a tide coming in that is unchangeable. That is the problem, I think, that the Conservatives are kind of reflecting, and I'm kind of supporting Mr. Howe here, not that before, but there's a sense, is there not, that the effect of the three limbs, the Section 4 DOIs that are always changed. We have the Prime Minister in Parliament saying, I have to change this because the courts require me to do so. Now, you may regard that as being political, trying to transfer the blame, but that's a norm that is now seems pretty close to a convention to me that is now binding on Parliament, that Section 4s are now automatically changed, especially following what happened in Burden, in ECHR, where the government committed to always doing it in an attempt to try and get to a point where exhaustion has been of 35 stuff, I'm not going to dwell. The ECHR, I don't want to go too much, but the ECHR is also binding on it's been conceded. Lord Phillips said, in the end, they've got to win. Yes, absolutely, that's right. They have to win. And the ECHR is binding on the courts, quite clearly. The argumenturatum locutum judici infinitum. You've got Bingham saying no more, but certainly no less. You've got Lord Brown saying no less, but certainly no more. I can't put any, there's no gap there. So we've got a binding human rights situation here where you've got an ossification of a classically 1,000-year-old, positivistic, flexible constitution ended. And we've done it in our generation. Who are we to do that to future generations? It's completely unacceptable, and that's why I think there's this backlash against it at this point.
Thank you, Robert. And then the gentleman halfway down, please.
My name is Robert Back, and I'm currently studying the Bar Professional Training course at BPP in London. Mr. Howe, there are, according to the Howard League, at the end of last week, 85,576 people in prison in the United Kingdom. According to the Ministry of Justice last year, there were 6,650 people on short sentences of below 12 months. I would ask you to explain what is your objection to those 6,650 people voting in elections?
Thank you. I think I'll start with Martin Howe and ask you to pick some of those questions to answer.
Indeed, I think quite a lot was directed in my quite a lot of the points were directed in my direction. Can I observe that what we're talking about is, I think, the fundamental wellspring is an issue of democratic deficit. Now, it may be old-fashioned to talk about democracy in these terms, but the idea of democracy is that the people vote for their representatives. Their representatives go to Parliament or whatever democratic legislature is concerned, and they make laws on their behalf. Now, we have a system where now in the European system, where the right of the democratic legislators to make laws on behalf of the people they represent is increasingly curtailed and interfered with. Now, you can, if you like, for political reasons, the sources of interference, that may be a jolly good thing, because there are people who believe that democratic politicians shouldn't be allowed to do too much, they should be constrained by lawyers and courts. Those people tend to be, by and large, lawyers and judges and so on, who have that mental attitude. But that's the wellspring, and there really is, I think, a fundamental difference between, or can be a fundamental difference, between the concept of the rule of law, which I personally believe is a very worthwhile concept, which I wholeheartedly support, and another concept which I call rule by judges. And they can become different when judges, instead of interpreting and applying laws which have been created by democratic means, instead take on a political role of making up laws and taking decisions that should be decisions for democratic legislators and not decisions for courts and judges. And I'm afraid this is a situation we have got into in the Strasbourg system. All sorts of courts, I mean, the US Supreme Court, for example, is an example of a case where a court has taken decisions which are more and more political, which bear very little resemblance to the actual constitution that they're interpreting. At the end of the day, in the United States, there's some sort of system for bringing democracy back. There is a mechanism for amending the constitution, even if very tortuous and difficult. And as FDR demonstrated, there's also a system under which the presidents can nominate judges to the court in such a way as gradually to rebalance the court so they don't go down striking down the New Deal legislation anymore. The Strasbourg system completely lacks any such democratic or corrective mechanism. It is inconceivable to get all 47 members of the Council of Europe together to make a fundamental reform of the court. And then this does lead one, with regret, that the only way to restore the rule of law to this country, as distinct from rule by judges, is potentially to leave the jurisdiction of the court. So that really is the upshot of where we got to. I was asked, why should prisoners sentenced to less than 6 months be deprived of the right to vote? I'm not going to answer that question. My answer is that is a decision that should be taken by Parliament, not by judges in Strasbourg, with absolutely no basis in the wording of Article 3 of Protocol 1 to entitle them to take that decision.
Thank you very much. I'm going to ask Lord Phillips and then John Wadham to address the point raised by Robert Craig about the reconcilability or not of the UK Constitution with the movement of, or the, I can't read my own writing without my glasses, with human rights discourse is the word I was looking for, if I may.
Yes, well, the first question is, what is our constitution? I think you were suggesting that the great thing about our constitution is that it isn't there, and we can, to some extent, make things up as we go along. But by signing up to the convention and to the Strasbourg Court, we have deprived ourselves of the flexibility which it would be desirable to have. And to that, I would say, I think there's quite a good argument about that. And if we were only thinking of ourselves, there'd be a very good argument to say we don't want anybody else telling us how to run our own show. We can do it very well, thank you very much. And I had a question for Martin, basically, is what, if anything, does he see is the point of the European Convention on Human Rights? We haven't heard anything positive from him about that. He may say there's no point to it. If so, fine. We shouldn't have signed up to it. We should let people go their own way. If you think there is a point to it, which is of setting a good example to others, and that there should be some kind of overarching discipline which can be imposed with sanctions, then if that's what we're about, we have to accept the bad with the good and go along with it for the greater good of the members of the Council of Europe.
I'd just like to ask Robert, which he could say, he can give me a drink later and explain to me why, if we go back 1,000 years, and you look at, what kind of structure did we have in Parliament? Who was there? When did we give people the right to vote? When did we give women the right to vote? Are all those part of our constitutions that we should have kept for 1,000 years? In other words, the processes of democratic accountability that we have now, put in terms of who's involved in the parliamentary process, the House of Lords, etc., the Commons, elections, women being involved in the process. I mean, presumably, if the kind of changes that the Human Rights Act and the ECHR makes, and this is something I'm not really sure that Martin addressed, are tiny. They may be important because they got on the front page of the Daily Mail, but they're tiny compared with, in fact, the sovereignty of Parliament. I mean, there may be arguments about exceptions. I don't think they are, but we can debate that. But they're actually, as judges often say, and lawyers say this too, that if there are three parts of our constitution, the judges are the weakest part of this, because generally speaking, subject to the convention, the laws can always be overturned by Parliament. It remains sovereign. It remains sovereign in the sense that we can opt out of the ECHR. It hasn't lost. We haven't changed that. You might think there were downsides, but there will be downsides of saying to women, okay, we've decided that you're not going to be able to vote anymore. There was, of course, but that's what Parliament could technically do. It can't do that for the reasons we know, thank goodness, though I'm afraid I wouldn't trust parliamentarians as much as I would trust judges, but that's a debate. Yeah, and it seems to me that in this context, people have talked about the democratic process, but yet they have failed to implement it. So that, for instance, if we didn't like the way that judges are appointed by the Council of Europe, we could change that. We just need to persuade other people, like we have to persuade other people in Parliament, the 47 countries, to change the rules. Because the rules are made, the UK is a member, and it can't persuade them, but that's the problem. And secondly, of course, if you wanted to change the issue about the right to vote, you could amend the convention. But no one has suggested this. Now, we were the chair of the Council of Europe up to the Brighton Declaration. None of these suggestions were made that we should change any of those processes, either the voting process for judges, make it more democratic, change the nature of the specific rights in the convention. None of that was done at all. I'm sure they wouldn't get support for it. So I'm really not persuaded about this issue about our beautiful constitution that existed 1,000 years ago, because I don't believe that's the case. And secondly, I don't think that and this is perhaps relates to Colm's point, which is I don't think there's no serious attempt by the Conservative Party proposals to deal with any of this. What there is a serious attempt to try to make sure that there be less criticism in the Daily Mail, because actually that's what this is really about. In fact, the statistics on polling figures are that about 80% of people in this country believe there should be a law to protect their human rights. Now, we could debate what they mean by human rights. It is also true to say that a large number of people, about half, actually believe that people abuse the rights that they have, and that's an issue that plays very well with the Daily Mail and the Conservative Party. So that's what partly this is about. So I'm afraid to say it's Euroscepticism, and it's Euroscepticism designed primarily to get votes. Now, I think we are debating processes and structures, whereas really we should be debating outcomes. Do we believe, in a sense, if you look at the judgments of Strasbourg on the domestic courts, do we think they're wrong or right? Should people have these kind of rights or not? Because, okay, you can debate the rest of it, but actually that's primarily what this is about, actually. And we don't like foreigners. That's why foreigners are mentioned regularly in the proposals by the Conservative Party. Foreigners will have fewer votes than British citizens, fewer rights than British citizens. Come and talk to me afterwards, I'll persuade you.
Okay, briefly going back to Robert's point about our inverted commas positivistic 1,000-old constitution. I can see that he hasn't had the benefits of a UCL legal education. Our positivist 1,000-year constitution is made up. I mean, it's Dicey himself, as soon as Parliament was just about to introduce the Home Rule Bill for Ireland, Dicey said, "Oh, that's unconstitutional. That goes against our fundamental internal values." This stuff is just nonsense. There's always been uncertainty, there's always been flexibility, there's always been a tension between alleged fundamental values like rule of law and the freedom of Parliament to do what it wants to do. That's part and parcel of British constitutionalism. It always has been. Nothing about the ECHR changes this. Parliament ties its hands self-ties its hands lots of ways, okay? When it allows unelected bankers in the Bank of England to set interest rates, I don't see people going, this is an appalling abdication of democratic power. The left wing of the Labour Party used to a long time ago. No one sees that as being fundamentally undemocratic. Tribunal on the Laws of the Sea, International Court of Justice, the entire international law framework. When the UK tiptoes into the waters of international law, it accepts certain rule of law binding constraints. When Parliament is now a devolution settlement, the sovereign Westminster Parliament has accepted some very extensive de facto constraints. Parliament ties its own hands in the greater good all the time, voluntarily. And it always preserves the option to walk away. It might be disastrous, it may pay a very severe price, as it would withdrawing from the convention. But it preserves that right to walk away. But the fact that parliamentary sovereignty is curtailed, made a little bit more difficult, doesn't mean there's any fundamental clash with democratic principles. The question is the particular hand-tying represented by the ECHR, is it disastrous? Does it wreck constitutional democracy in the UK? I argue on a simple cost-benefit analysis, no it doesn't. We're talking about a few cases that certain people don't like, perhaps rightly, perhaps wrongly, versus huge gains historically in terms of the impact of Strasbourg jurisprudence on our domestic law, but also huge gains externally in terms of UK signalling commitment to rule of law, human rights, Europe and the outside world. There's nothing fundamentally incompatible with core constitutional principles there.
Thank you. Can I take another 2 or 3 questions or interventions? Hands up. I've got one there. And anything else? Anyone else? I'm going to one there at the back and one there and you at the front. So if we go anti-clockwise, I can't see you now, but somebody had their, yes.
I'm Blaise Matthews, I'm afraid I'm from UCL. But this is a question I want to direct to Colm, who picked up on it just now, and Lord Phillips. There's been a lot of academic and judicial excitement about this idea of common law constitutionalism, this idea that we can go back to our pre-HRA roots and Magna Carta somehow in a post-HRA age, and that we can protect rights in that way. I just was interested to see what your perspective on that was, and if the whole human rights framework that's been built up was dismantled after this election, if there was actually a resurgence of common law rights, and if that would be a good thing or not.
Thank you very much. Nice and brief. And there was one at the back. Yes.
I'm Isaac Preston. I'm just a normal six former, so nothing special.
Welcome.
But I was just wondering, we're talking a lot about the curtailment of democracies, if that's the only ideal that matters in society. I went to a really good talk at Edison a few months back, which was talking about parliamentary sovereignty, and actually where do we get that from, how legitimate is that? Actually as an ideal, I'm not saying that I'm completely against democracy, but that's not the only ideal to which maybe we should subscribe.
Thank you. And then there was other lady at the front, yes.
Oh, yeah. I'm Johanna Bittenbinder. I'm a law student at King's, and I just wanted to question Mr. Howe's attack on the making up of the ECHR, that they are making up rights, because they propose that they're a living instrument, so that they're adapting the rights to time, and it's for the purpose of optimizing, improving the protection of human rights, and I don't see the democratic deficiency in it, because who wouldn't want better protection of their own rights? I don't. Could you explain to me, could you explain what the democratic deficiencies are, or what's the problem?
Thank you very much. If we go left to right, I can't tell my right from my left. Right to left. We'll start with Colm, and just 2 minutes, if you would, on any response you have to any of those points.
Well, just very briefly, I think if the HRA goes away and we have a homegrown Bill of Rights and our common law rights development, it'll be a really interesting and really uncertain situation. I think no one will quite know what the situation is with 20 years worth of precedent. It will put Lord Phillips' successors in the court in a very, very difficult position. They will have to do a lot of they will have to do an awful lot of judicial creative interpretation. There'll be a lot of activist and non-activist interpretation going on there, which may be an unintended side consequence of attempts to eliminate or reduce the influence of Strasbourg.
Yes, I mean, picking up on that thought, it may well be that, if you like, disconnecting from the Strasbourg jurisprudence and inviting our courts to start comparatively fresh on interpreting the convention text may lead to judicial boldness in the interpretation. I don't see that as a problem. That may be a proper function of our judges. In our system, at the end of the day, if Parliament can't stomach a particular judicial decision, Parliament has the ability to change the law. That's part of our constitutional dynamic. I think, to pick up one point that you made, which was the human rights involve not just consideration, is this good for a particular right or for someone's rights? They involve questions of balance. In many situations, human rights are balanced against other considerations like the maintenance of law, the security of the state, other considerations, or rights. One may be balanced or conflict with another. The classic conflict being the right to freedom of expression of a free press and the right of privacy of individuals. It doesn't seem to me that just saying, oh, well, human rights are a jolly good thing, we must have a living instrument, and flinging around a lot of ill-defined and vague phrases justifies the assumption by judges of legislative and political powers. And I think that's a fundamental point. Now, finally, just to come back on a point made by Colm and indeed similar point made by Lord Phillips, who challenged me at the end of the previous, and that is the international effects if the United Kingdom were to depart from the convention. I don't minimise this. I think everyone recognises that it is of value internationally for the United Kingdom to be part of the convention system in order to maintain the credibility of the system. But at the end of the day, we have to take a decision. Should we carry on subjecting ourselves to the slings and arrows of this outrageous court solely in order that we hope that President Putin may pay slightly more attention to the judgments of the court than he does at the moment? And I think you have to be realistic about this, and it's a matter of balance. This issue of having this sort of international court, there are plenty of civilized countries around the world who protect the individual rights of their citizen, who don't feel the need to have an international human rights court supervising their own Supreme Court or equivalent body. They leave those tasks entrusted to their own judicial system. Canada, for example, Australia. Why on earth we in this country feel we need this external source of jurisprudence, which other countries seem to be able to do without, is a matter to be questioned.
Thank you very much. And John?
Yeah, just briefly. I think that illustrates the problem, because let's assume for the moment, actually, first of all, in the Inter-American system, there are very significant numbers of countries that are signed up to the Inter-American Convention. In Africa, there is an African Charter and there's a court and a convention. Across Europe, there are 47 countries. In the United States, they have a Bill of Rights. There is an issue about Asian countries not having a mechanism, but actually the vast majority of countries do have a externally imposed set of rules. Now, whether how binding the courts are, etc., and all of those issues are complicated. So I'm not sure that point's right. But the second thing about the common law that people mentioned, I don't believe that if there was a Bill of Rights based on the proposals from October from the Conservative Party, and judges made decisions on the common law, taking into account the decisions of the Canadian Supreme Court, the US Supreme Court, and the Inter-American Charter and the African Charter and Strasbourg, and they decided that prisoners were entitled to votes, or prisoners that have been in prison for a month or a week were entitled to votes. What's going to happen? Well, the answer is nothing's going to happen, because the Bill of Rights being proposed is is completely weak. All it says is you must think about human rights when you make a decision. Well, I used to practice in this country when before the Human Rights Act came into force. So we used to go regularly to the courts and say, you should take into account the European Convention and this other charter and this Bill of Rights and this. And what happened is the judges said, well, actually, the law seems to be very clear and Parliament have laid this down. So this individual's person's rights won't be respected in this court. And I know that that's the case because then we went on to Strasbourg and got a result. So the issue is not just it's not just what convention or what jurisprudence is attached to that convention, or whether or not we could devise a Bill of Rights. And I've been I've with colleagues written a Bill of Rights when I was at Liberty. We could all do that. The question is, what is the remedy? Because rights without remedies are no rights at all. And actually, in practice, what this means is that you won't get rights. What happens is, if Parliament has said something, that's the end of the debate. The courts really can interpret it, but actually, what happens is this is a supremacy of Parliament in a simplistic and way that I don't think is something I would like to see in the 21st century in this country, and because it's not reflected anywhere else, except in some, unfortunately, less than democratic countries which we could name.
Yes, the question was, can we go back? Can we tear up the Human Rights Convention and go back? And I'm going to end on a note of controversy. And I say, I don't think we can. We have a parliament that is supreme, but we don't want a parliament that is completely supreme. We're talking about having a Bill of Rights, our own Bill of Rights. But is that just going to be an ordinary statute, or is it going to have some kind of constitutional overriding effect? I think the answer is yes, it is. We recognise that we cannot trust our parliament to, without any inhibition, to pass any act it feels like. If we had that situation, we'd have a lot of people locked up now without trial, because that's rather more convenient than the degree of liberty that we are bound to give them.
I don't think I can add anything to that. So it just remains to invite you to thank all the speakers, and there'll be a drink afterwards, so I'm not exactly sure.